Today, I'm back with a lawsuit out of Missouri to shut down the THCA peddlers that think it's legal. Of course, the DEA and some case law disagrees. I'm attorney Tom Howard asking for likes and subscribes for legalized, regulated cannabis markets. Let's dive into it with our slides. This complaint was just filed in January 2026, so we will have more on this. You want to follow along? There's a QR code that you can scan to get our newsletter that will deliver new videos and all sorts of interesting tidbits to your inbox. And here we are with THCA Hemp is eating your lunch. If you have a cannabis license, the Missouri license holders aren't going to take it anymore. They filed an action. Let's get into why it is what they call unfair competition. So this is the tax compliance problem. Now, if you're a licensed operator, you have thousands of dollars of annual cultivation fees or other licensing fees. You have to pay excise taxes. You have mandatory security systems. Regulators stop in to your business on a regular basis. Metrics, seed to sale, restricted banking. You get debanked. It costs hundreds of dollars a month to bank. You really only get treasury services, but the hemp smoke shops get none of that. And some of them will actually take credit cards. They'll ship direct to consumer online. The industry out of Missouri is calling this unfair competition. And of course, what is THCA? THCA is just the raw cannabis plant before it's been lit on fire. It is the precursor, according to the DEA, and it's really just marijuana that has not been lit on fire yet. But the 2018 Farm Bill defined it as Delta-9 THC. Of course, it defined testing as total THC. Though the testing had to only be done once when it was cultivation, no more than 30 days before harvest. And that fixed in amber the date as which the THC, total THC, was compliant, which is hilarious considering that, the vast majority of cannabinoids occur in the last 4 weeks of flowering. And that's one of the reasons why if you use gas chromatography, you can collapse the, fraud so that it is all total THC or decarbed total THC, because when you heat through gas chromatography, it makes the acid on the THCA pop off because you've used heat, and it results in the Delta-9 THC. You can also use just HPLC, high pressure liquid chromatography, and then just add the THCA and the Delta-9 THC. But of course, then you have to do a little bit of math to the THCA to reduce the weight of the acid. Now, the total THC standard, that is the federal law. The federal guidance said that you have to do THC compliance on total THC. The loophole on that is it has to be no more than 30 days before harvest. Watch for that to change, especially after the new hemp definition is effective in November of this year. The DEA confirmed that THCA is included on a May 13th, 2024 letter sent to Shane Pennington. We've done videos on that. And then just in November of 2025, the DEA, the Department of Justice, was prosecuting a person who had a medical license in Maine, and they tried to suppress evidence because the DEA tested all of the marijuana and it said that it had more than 1% THC, total THC, using gas chromatography. And the defense was trying to argue that the THCA amount meant that it was literally hemp. Did not work. The motion to eliminate was granted. They were not allowed to give any evidence on that. And if it is more than 1% THC by gas chromatography, the DEA, the federal government, does not consider it hemp. You do, though, because you want to make a quick buck without any regulations. And so here is the proof of concept lawsuit that has been filed in Missouri against, this is just, look at that. That is a dog pile of a caption right there. As a lawyer, I can tell when it's a dog pile of a caption. The Missouri Coalition comes together, 20 plaintiffs, a crapload of defendants, and then that just filed late January. We'll have to see how this all plays out. They're probably still getting all those defendants served. So what's their legal argument? Unfair competition. They are saying that what the hemp industry or the THCA industry in Missouri is doing is essentially trafficking a Schedule I substance, which is a felony, and they are unfairly competing with the marijuana industry that has licenses. Now, of course, the motive is obvious, because if you just say that it's hemp and it's THCA, bro, you just bypass the entire regulatory regime and all the costs, rules that go with that regime, like having a license, like having a compliant security system, like having a special use permit so that you can be zoned. All of that. And then that tort that they have, and a tort is just a legal wrong. It's not a contractual problem. It's more like a personal injury. Those are torts. Now that you know what that is, thank you. That creates an illegal competitive advantage, allegedly, according to the plaintiffs. One of the things you need in a lawsuit, of course, is damages. And then you need the court's ability to give you that redress, which means like grant you relief. What are the damages? Well, the defendants haven't had to pay the thousands of dollars in licensing fees. The defendants haven't had to pay the hundreds of dollars, which adds up to thousands of dollars in testing costs. The defendants haven't had to pay for vaults, cages, HD cameras. Oh my goodness. Our dispensary's security system, just to lease it, was $38,000. And that's basically 50%. And then there's a monthly. Yikes. And then, of course, operations. Our bank account is $500. Comes with cash handling, which would probably add another $1,500. And they have credit card processing. Not that there's a hemp merchant code. They probably just put like general retail. And then, of course, standard retail shelves, no real lab testing. Most of the THCA products are probably grown illicitly, and they're on fake COAs. What are they asking for in this lawsuit? Injunctive relief. That basically means stop it. That is what an injunction is. You have to stop it. The court says, don't do that no more. And it's right there. Court order legally barring the defendants from marketing or distributing any of this THC product that has more than total THC content over 0.3. And so that is their primary goal: stop the unfair competition. Now, how can you prove this and set this up for your state if you're watching and you have a licensed dispensary and all these THCA people are selling the same product just down the street or across the street from you? You can go into there, and this is where chain of custody comes in, because their COAs are kind of garbage, but you would have to show that you went in, bought the stuff, sent it to a reliable lab who tested the stuff, and its total THC was more than 0.3 Delta 9 THC, because you accounted for the THCA by decarbing it. That would be your evidence. And then you can litigate it. What is the primary claim? Typically, it is an unfair competition or deceptive trade practices, because think about it, like THCA flower really is entrapment. You're gonna make this weird claim that it is completely legal hemp, but it's in a pre-roll, and you sell it with a lighter, it comes with a free lighter, and then they spark it. Now that's their problem. Just like, if you sell them a kitchen knife and they use it to commit a crime, that's their problem. Now, a kitchen knife has a different use. The only use for the THCA pre-roll is to smoke it and turn it into actual Delta 9 THC. A lot of the people that watch the program, they don't care. They don't have licenses. They think that it's legal, and lawyers, if nothing else, this is to the bar that's out there that has enabled this. Stop it. Stop being an enabler. You are enabling this type of behavior for money. And you were supposed to apprise them of the federal law. A lot of the legal opinion letters that I've read fail to do that appropriately. But that's my pontificating. Nobody likes that. Who really likes pontificating? Come on. No. Okay, fine. Back to the stuff. If you are in a state that is both legal and also full of THCA flower, there is a test case that's going on in Missouri right now. You probably could bring false advertising, public nuisance, common law misrepresentation. You really have to check the laws in your particular jurisdiction to see what types of consumer protection or fraud or like unfair competition that you can bring. Missouri was bringing it. What other jurisdictions could? Here in Illinois, we have unfettered hemp competition, which makes no sense at all. Like, why do you even have an industry? You also see similar stuff. Well, Ohio's starting to crack down. Many of the states are starting to crack down. Even Texas is starting to crack down. And then, of course, this is February. This isn't November. And so before November, that's when the federal law that has been passed goes into effect. And, newsflash, there are no must-pass bills between now and November. There's just not. So what? There's going to be a partial government shutdown so that the Democrats can defund ICE. The ag bill has been funded, so they don't have to revisit it. And moreover, 3 out of 4 senators voted for it, and then Donald Trump signed it. That's the other thing. You don't usually fix a problem before the election. You fix the problem after you run on promising to fix a problem. You don't run on the record. You need a crisis or a problem to fix, but whatever. And so Q4 is peak retail holiday sales. Of course, November. Who's doing your weed shopping for Christmas in November? It'll be very difficult for this stuff to be sold after November 12th. It probably even into the fall as banks start to tighten their policies. Why are people picking this policy as opposed to just letting the regulators or letting the legislature do it? Because in my state of Illinois, the hemp lobby is stronger than the cannabis lobby because the hemp lobby has about as much money, so 1.x billion dollars a year in the hemp industry, and no rules. And so they have a lot more free cash flow to buy lobbyists. And then that means that nothing gets done at the legislative level. So speed, litigation, TROs, they move a lot faster than the regulators or the legislatures. And then, of course, science. You have irrefutable proof once you take that THCA diamonds or hemp pre-rolls down from the shelf and go test it. It's going to come back at like 20% delta 9 THC. Then, of course, finally, cost sharing. You remember that dog pile of a caption where you had a bazillion plaintiffs, 20 different plaintiffs. So the lawyer is sending an invoice and dividing it by 20. What's your immediate next steps? If you are a license holder that wants to explore this, you can find 5 problem stores that you have, and you can then go do the buy phase and gather some evidence. And then if you want to discuss more, you can contact me, Tom Howard. And then there's my contact information over there. I may not file this lawsuit because I have to get our dispensary open, but I might be a plaintiff because why do I have a $60,000 safe and a $70,000 security system to buy cannabis that is from seed to sale with an inventory control that is grown in Illinois on a license that has recall authority, and I could just be selling it? That makes no sense. So that is the lawsuit that's going on in Missouri about THCA. If you're selling it, let us know in the comments. If you're not selling it, let us know in the comments. Don't forget to tune in. And if you made it this far, thanks so much. I'm asking for you to subscribe and give us a like, and I will see you when it is 420 somewhere.